So what are we talking about? We're talking about a case that started in the 1940s and got interesting around the 1970s and didn't actually make it to court until the 1980s. This case is about, it's very interesting. It's about a group of women who put together a class action lawsuit for their injuries, which were the presence of adenocarcinoma and other cancers as a result of their mothers taking a drug while they were pregnant with them decades before. So where does this begin? In 1941 to 1971, in that time frame, the FDA authorized a drug called diethylstilbestrol. If I have time, I'm going to get my daughter in here to try and say that, which will be fun.
We're talking about diethyl something. What is that?
Ready, Addie?
Diethylstilbestrol.
Perfect.
DES. This drug was being taken, it was being marketed and distributed for the prevention of miscarriage. So many thousands of women were taking this drug at that time. And as it turns out, 10 to 12 years later, people were learning that these children of the mothers taking DES were showing cancer growths that were notable and needed to be investigated. The FDA reacted to this, and in 1971 went ahead and told all of the manufacturers that they had to cease marketing and distributing DES, and that they also needed to notify all the physicians and the public about this concern around DES and having taken it for miscarriage prevention, and the possibility that had you been carrying a female, that they may have this increased risk for cancer. So the Superior Court of Los Angeles and Ventura both they dismissed these cases based on the plaintiffs not being able to identify a specific defendant for their injuries. So this, it's not surprising. It's a conservative move. It sticks to traditional law around the subject. You don't normally hold people accountable when they don't have the evidence to identify the party who's at fault, which is sort of the problem here. The appeal to the Supreme Court of California is where it gets interesting. So let's talk about the issues here. Can a manufacturer be held liable for damages under the product liability theory that result from a drug where the plaintiff cannot identify the specific defendant manufacturer who produced the drug that the plaintiff's mother took? It's a very interesting question. So the Supreme Court felt that the injury to the plaintiffs was significant, but it's complex because there were 200, actually more than 200 manufacturers involved with making and distributing DES during that 1941 to 1971 period. So product liability on its own seemed to be lacking the teeth and the broad definition needed to sort of live as the structure by which they would try and hold anyone accountable for these injuries. Another piece of the puzzle here is something called enterprise liability. And the concept of enterprise liability is a doctrine where multiple entities can be held accountable, jointly liable for an action or a problem, in this case these injuries, to defendants. The examples of that historically were simpler, so they had to take things a step further. And they brought up the theory of market share theory. This is a doctrine that allows a plaintiff to establish a case based on safe assumptions of the first impression, or prima facie, against a group of defendants, in this case manufacturers of DES, even when the plaintiff does not know which of them is really responsible for their personal injury. So they're holding people accountable, giving them the opportunity to prove that they shouldn't be held liable with evidence, and in the absence of that evidence, then held accountable, apportioned by their market share of the distribution and manufacturing of DES. So how do we close this out? The women involved here and the Supreme Court of California, along with the manufacturers, I think ended up getting a fair shake of all this, where the Supreme Court really went out on a limb to try and make sure that manufacturers were not escaping liability for such an egregious injury to so many women. When you're marketing and distributing a drug and not really following the rules that the FDA had set up for you, they were stipulations. They had to warn physicians and patients that it was experimental. They were supposed to put a warning label that outlined all of the risks, and this was not done universally. They also were aware it was carcinogenic. This was something that was not widely distributed as part of the package of information with the medication. And so there was negligence present that caused harm. And even though the women who suffered injury by way of getting cancer could not identify which specific manufacturer was responsible for the specific drug that their mother happened to be taking while they were pregnant, normally would prevent them from being able to hold anyone accountable because it couldn't identify them. But the court saw that there were innocent plaintiffs and negligent defendants, and that's how they came up with this market share theory. Each defendant was allowed to provide evidence to show they were not responsible, and if they could not do so, then they were held accountable for their market share of this problem. I think it ended up being a good thing, and I think it serves as a precedent warning to industry that if everybody is doing something a certain way, including not following guidance from the FDA about a specific drug, it still isn't okay. You could still be held liable for mistakes like that, even when a plaintiff can't prove that it was you specifically. And that's all I have for you.